So I've been asked to make some essentially opening remarks and address the points in the briefing note. The first item that I'm struck by is the title, New Ways of Working. I'm struck by that because it is, for my part, from the perspective of the private branch of the profession, and I refer here to the solicitors branch of the profession, the most important feature of the next 5 to 25 years, depending how fast one judges the rate of change to be. So by way of introduction, I'll explain why I make this statement. The story has to begin around the end of the Second World War, when the world was being recapitalised and attorneys were needed for the deployment of capital. And we all know the story of Baker & McKenzie. 1949 it was formed in a taxi in Chicago, and by 1954 it had its first international office. And what we saw was the rise of a few American firms and the London firms in the subsequent decades serving this need. And we changed from the profession of law to the business of law as a result. It was of necessity. And during that time, all law firms were modelled on what is called the Cravath system of Cravath, Swain and Moore. He enunciated, you'll still read it on their website, best practice, we'd call it today, in developing an attorney. It was the apprenticeship system. It, of course, created a business model for the owners of the firms. And firms have only very, very recently, 60, 70 years later, begin to understand what this business model is. So it's a very long-standing, no practicing solicitor has ever experienced this. We are seeing a phenomenon where the breakaways from the very large firms, and the next witness is one, as I discovered this morning, are beginning to recreate the profession as it was 60 or 70 years ago. This business model, we have coined the phrase big law. It's a neologism quite deliberately, the capital L and the elision, to connote a business model and to contrast it with the coin again that we phrased in the phrase we coined in 2013 of new law. I'm not going to address the new law business model, but as we go through here, you will begin to appreciate that it is the exact opposite of the big law model. So a business model is not competitive strategy. A business model is how the enterprise, whatever it is, makes money, makes profit in a for-profit environment. Law firms, at their simplest business model structure, have to win work, do work, and create an infrastructure of governance, leadership, and a platform on which the solicitors practice. So when we look at how work is won, in the traditional big law model, every law firm of more than 5 or 6 solicitors, not owners, in Australia and elsewhere, it wins its work by being partner-centric in the sense that the personal brands are what attract the work. We still hear this dominantly, we hire the person, not the firm. That is still the prevailing norm. It is eroding, but it is still. Where lawyers are expected to both sell and produce. There is no specialisation and separation of function between winning the work and doing the work, which is peculiar to this profession. And still very largely, the risk of the price is borne by the clients, their hourly rates. They're input-based prices rather than outcome or results-based prices, or even output-based prices. Now, all those things are beginning to change. But when you look at the prevailing norms and the psyche of firms and the practitioners in them, they are partner-centric, lawyer-centric, and hourly-based rate psyches. And all the symbolism, all the metrics, the entire culture, the measurement systems, the dashboards, revolve around this. Secondly, how is work done? How is work produced? The profession prides itself in legal excellence. I often summarise this, not being a lawyer myself, that 10 drafts is better than 8 drafts of a letter of advice. We have a culture of perfectionism. Firms fight tooth and nail to win the top talent from law schools. the notion of fit for purpose really doesn't apply. It is top talent, and it is judged in terms of academic and other indicia of excellence as talent in legal practice. The leverage model has been created. A very famous book in 1991 from the University of Chicago wrote The Tournament of Lawyers. And firms conduct a tournament. One has to be brutally frank about this. There is a fight to get equity partnership, although the current generation of solicitors is showing good signs that it's not so willing to fight and claw its way into equity partnership. But nevertheless, the firms make most of their profit from the leverage model. Firms adopt sustaining technologies, in other words, to help lawyers do their work faster or better. And they use processes that can continuously improve the work they do. So, in fact, firms are, the way they do their work, they are reinforcing the culture of how work is done. And finally, how the firm is governed. It's run as a partnership, whether it's incorporated legal practice or traditional partnership. The behaviours, the cultures, the norms, the attitude towards building balance sheets, profit today, no balance sheet in the firm, prevails. And firms seek to have the minimum possible, as in for reasons of client service, number of partners. So it's a profit maximising machine that has been extraordinarily successful, both for the clients and for the owners of these firms and the future owners of these firms as the pipeline of equity partners builds. So you have 6 decades of undoubted success. And as David Maister once famously said, how do you tell a room full of millionaires that they've got it wrong? And this is the challenge that the profession has, and this is why the profession needs leadership, including from this commission, to help it understand that things have changed, and they are going to change more and more and more. The wonderful science fiction writer William Gibson writes, "The future is here. The difficulty is that it's unevenly distributed." Nothing I'm talking about, nothing I've written about in co-authored with Imi Kashner in our book, Remaking Law Firms, is going to happen. Everything we have written about is happening somewhere. The wind is full of straws. The challenge is to put these together. So the consequences of this big law business model are a culture embedded in the profession, in the way law schools think about those of their graduates that are going to go into the profession, and embedded in the institutions and the symbols of the profession, the law societies that represent the profession. Now let's look at what's happening in the environment around, and this is deliberately clouds with some patches of light through the dark clouds. There are forces at work which are beyond the ability of any part of the profession or the profession as a whole, or any with a stakeholding in the profession, like the courts, other regulators, law schools, to influence. These forces are at work, and I'll simply enumerate them. And I refer here again to the private branch of the solicitor's profession. I will make some remarks if there's time about small firms, solo firms, and how they fit into this schema. There is hyper-competition, and hyper-competition is a state that occurs in any industry in its mature phase, i.e. the demand isn't growing, the demand may well be shrinking for, say, the top 20 or 30 law firms in Australia by size, which means they engage in more and more fierce competition, and more of that is price-based. Secondly, we are in a deregulated or deregulating environment. Australia has led the way in many ways in the world. I don't believe that our law firms actually picked up on the opportunities from this, and others are now beginning to eat the lunch of the law firms, and I refer here to the accountancy firms, particularly the Big Four. The clients are being transformed, and I will show in my last slide how this is playing out. The way clients buy legal services is being transformed. The procurement phenomenon is much more than just introducing people with an additional set of skills to appoint panels or to appoint law firms to particular matters. It is a state of mind that clients have, and it manifesting in a whole range of ways. Can we prevent legal problems? It's called the do less law movement. If matters do become legalistic in some way or require a lawyer's attention, can we do this in-house? Or can we do it in a way that is not conventional, i.e. brief an external law firm and I refer here to the new law firms. And once it does go outside, how do we contain the cost of it, to external counsel, that is? And the transparency of pricing, which is manifest and it hasn't yet arrived in Australia, the e-billing phenomenon, and the publication of every minute detail of a matter that is transparent to the client is coming to our shores soon. Exponential technology, and there have been plenty of hearings, witnesses in the hearings about technology, is being embraced by clients faster than it's being embraced by firms. So this is now a really client-led transformation we are seeing. And finally, because of these cultural aspects that I've referred to, there is inertia in the law firms. She'll be right. It's an extraordinarily long recession since 2008-9. We've seen this before. We don't have to do anything. We have to wait, is a prevailing attitude of workaday partners. It is not the attitude of leaders, and there's been a growing disconnect. My final slide is a piece of work we've recently published since our book came out in March. We've shown for Australia and 5 other major regions of the world what we see as the changing market shares between the participants in the legal supply chain. On the right here, you'll see the in-house work growing, and these are 5-year periods we're looking at. On the left, in black, we have the traditional big law firms, and they are, some of them, remodeling themselves, or in our language, remaking themselves. We see the emergence of a small proportion of new law firms, including the LPOs, LSOs, and other platforms. And we are seeing standalone document providers increasingly coming in and providing service in their own right in the cognitive computing space. And if you stand back and look at the really big picture, to me, this says it all as to what the profession needs to do in respect of its big law participants. The economy, the community needs these firms. They have to remake themselves or face the consequences, which is declining profitability and eventual decline of the business model of these firms. So I'll end there, these introductory comments.
I have a question, George. Where would you put the big 4 accountancy firms that you referred to before on that graph? Are they a new law?
No, not at all. The new law model is a corporately owned, technology-enabled, very often small and virtual. It's dispersed. You can't see them because they're everywhere. The big 4 are clearly in the big law model and are, because they have these very large platforms and global reach, transforming themselves into remade law firms as we speak. So as they grow, there's an announcement today by KPMG in the UK, they are not adopting the old ways, they are striving to adopt the new ways.
George, you said that the big firms have to remake themselves. How do they remake themselves, and are any actually going through that process now?
We're seeing signs of it. You go back to 2005, you'll find Alan Over in London, Seyfarth Shaw out of Chicago originally, pioneering the way and showing what can be done. In more recent times, we've seen the evolution of second brands, the so-called virtual firms. Of course, Chambers Westcott with Orbit, Minter Ellison with Flex, McInnes Wilson, a small firm with Lex Voco, growing extraordinarily rapidly because clients are embracing these services. We will see Pinson Masons bring Verio to Australia, and you can go on with this. So that is one aspect of it. The other aspects are the culture, how work is done, the adoption of disruptive technologies, not sustaining technologies, and above all else, the education and retraining of partners, many of whom are not wanting to be retrained and will leave.
You briefly mentioned small firms and sole practitioners.
Yes.
What lies ahead for them?
The profession is going through a dichotomy of consolidation on the one hand. The big are getting bigger. All over the world. In our view, within a decade, we'll see $10 billion law firms in the world. That's 4 times bigger than the biggest now. So it's a similar path that the accountancy profession trod. And at the same time, it's fragmenting. So we're seeing 2 kinds of fragmentation. The breakaways, setting up boutiques or specialists or focused firms who have a very precisely defined patch that they focus on, often with a very broad geographic footprint because clients will go to the specialist wherever they may be found. They offer value propositions which are superior, which are very often better, faster and cheaper. So we're seeing the breakaway phenomenon, and we're also seeing the startup phenomenon, where people are starting from scratch. This is young people, recent graduates, having the courage to go out and start practicing in a new way. So we will see a growth of these firms. They are micro firms more often than solo firms. Many of these will be working from no fixed office. Many will embrace, in our view, a chambers-style model where the back office is taken care of. And out of Kuala Lumpur, listed on the Singapore second board, we have a very fine example, the first in the world, in the form of Zico, Zahid Ibrahim's, the original Zahid Ibrahim firm, which is offering throughout Southeast Asia, excluding Australia and New Zealand, at least for the time being, complete back office services to very small firms of a very high caliber. So we already have that model operating in our own backyard. And in our view, there will be a lot more of that.
Your slide up there shows an increase in client in-house counsel and the legal services they provide. What about government lawyers? Is the trend similar there?
Yes, to the extent you can measure it. It's very, very hard to measure exactly. This is government lawyers practicing law as opposed to advisors, policy officers, and so on. So the practitioners, practicing certificate holders in government, would appear to be so. Now, whether this is got a long cycle of in and out is not clear. Our view is that technology will mean, and that's why the rise here, or the US or Canada or England and Wales, where we've looked at, of the in-house is relatively muted. The share increase that we're seeing in this chart is relatively muted. It's because corporations, including governments as buyers of legal services and users of legal services, are finding new ways faster than the big law firms are able to provide. So they're going direct to the LPOs and the LSOs. They're adopting technology. If you just have to look at what Riverview Law is doing with artificial intelligence for large corporate legals departments out of the UK, you will see within 12 months they've gone from a standing start to being embedded in half the banks in the United Kingdom in 12 months. So that rate of change suggests to me that more work will be done, but it will not employ more lawyers necessarily pro rata.
How big is the threat from the accounting firms, the legal profession?
Well, the legal profession, as the law firms of the legal profession,
the private profession,
very substantial. You're dealing with firms with revenues globally in excess of 30-40 billion. They have massive platforms and are way down learning curves how to diversify. On the record in my book, Leon Flavel, heads up PwC worldwide, says we intend to be 5,000 lawyers within 5 years, which is 3 times bigger than we are now. That would have taken him at the time he made the statement to be the largest provider in the world. Dentons is now ahead of that. We see yesterday the United Kingdom KPMG firm appointed a head of legal, and they are branching well beyond the traditional spaces of employment law, migration, expats that they have traditionally occupied. And our view is that they will embrace the spaces in the high-end work of capital markets, IPOs, that are currently held by the leading firms of any jurisdiction, notwithstanding what they say to the contrary. And I am aware of some very substantial global firms out of the mouths of their global managing partners saying, we have taken all of our work, both our audit work and our transaction work, away from naming 2 Big Four firms and given it to naming 2 other second-tier accounting firms, as in much smaller, because we are now in competition. And we are not going to share our financial details nor our know-how with these firms. So the leaders are seeing this. When you talk to the workaday partners, they shake their heads and say, well, I don't compete with, and they name people in these firms because they can't see the future. Our view is that these legal practices will become substantial new sources of profit for the so-called Big Four firms.
One of the questions I wanted to ask you, and I might just make it open-ended to start with, but what are the ramifications of these changes for young lawyers, for prospective lawyers, in terms of, I guess, employment, where they get their sort of, that sort of fundamental skill set that they would be after when they come out of university?
I would say to people who have children in law school or contemplating law school, read the appropriate chapter in Richard Susskind's book, The New Jobs for Lawyers. He lists 10, and he wrote that about 4 years ago. So I think there's a great future for people with legal qualifications. Finding jobs is getting harder and harder. We've all seen the stats. Length to finding a job has gone from months to years. In fact, my co-author of this book, Imi Kashner, he was a remarkably talented lawyer, was working for me, and we wrote the book together because she couldn't get a job in a law firm. It's ironic. She now has in a new law firm, rather than a traditional law firm. Much longer path to traditional learning in a law firm and embedding in a law firm. We are seeing corporations take graduates directly into legal departments and now begin to offer training. That is a new trend all over the world again, not just in Australia. We are seeing new law firms saying we only hire trained people. So the growth of new law, small as it is, as the chart shows, they are hiring people 6, 7 and more years out. There were some stats yesterday out of from Potomac Law in the US, showing the average age of their lawyers, a virtual law firm, is 20 years out of law school. The average intake is 7 or 8 years out of law school. So there's going to be a training hiatus. There's no question about that. And again, all the evidence suggests clients are now saying, we will not train lawyers, therefore you have to find a way of training them yourselves, not at our expense, please, which threatens the leverage model, which severely threatens the willingness to shed work from more senior lawyers to more junior lawyers, where appropriately the work should be done for clients. So we see a major need to find a way to help the whole ecosystem recognise the deficit that you're talking about there, Michael, the gap.
Because it does seem, when you look at your the graph there, there's growth in areas, there's new opportunities,
Indeed.
but it's not clear that they're necessarily opportunities for new lawyers. So I take it from what you're saying, you might get that in say, in-house legal services. They might be prepared to take on people, but in somewhere like new law, that's not really their approach. It's
not for the established new law, but these young people are creating their own new law. I've met in Toronto, which is a hotbed of innovation in this space. Young lawyers straight out of law school, in fact they start before law school, building apps, selling their apps 3 or 4 years out and going on to the next development, coalescing in innovation districts, creating their own jobs. You know, it said there's an app in every one of us. Well, I think there's a lot of apps in a lot of young lawyers who are seeing these opportunities. I met a graduate of Monash the other day, a young Australian Chinese, who is so committed to improving the criminal justice system for minority groups that he's building apps as a lawyer to educate the community about the risks to young people and how to stay out of the criminal justice system. And he has got a thriving business as a lawyer, but the most unconventional if you think about where lawyers have trained previously. So we see a vast array of opportunities, but they don't lie in the conventional places. That conventional path is getting smaller because of the phenomena on the chart.
So are you saying then this is a great opportunity then to really mop up a lot of excess capacity, because as long as people are open-minded as to
Absolutely.
to how they approach
We've really
their
only
career.
talked about business-to-business law here, and my whole work has been in business-to-business rather than consumer law, access to justice for the consumer, the individual. If you're a devotee of Clayton Christensen's theories of disruption, we are not going to see, and we are not seeing disruption in the big law space. We are seeing huge distress, but it is not disruption, a la Christensen. Christensen refers to the low end of the market where there's high volume, simple need that is unmet and often latent, which is what Uber did. We are not Uberizing big law, but we are beginning to Uberize consumer law. These are startups, Rocket Lawyer, Legal, Zoom. And when you're owned by Google or Amazon, you can imagine the impact that these are having. And I don't think we've seen anything like the manifestations of what is coming. Australia's own law path, when you look at the growth of downloads on the law path, from the law path website, the data they publish periodically or share periodically on Twitter, it's just staggering, which speaks to the unmet demand. Look at the surveys by the Solicitor Regulation Authority in the UK that shows of small business, only 15% of their legal needs that they recognise do they consult a solicitor about. The majority is family and friends, or ignore it, or consult your accountant. So there's 85% of a patent market that's unmet by solicitors, because the traditional form is unable to do it. So the new forms are emerging, which we've called new law. And nature abhors a vacuum, consumer demand abhors a lack of supply. So the supply is being sucked in from all these many sources. And we are seeing solo practitioners in Australia. There's a family law practitioner in Victoria who's effectively created a new law firm in family law because she's so distressed in her particular ethnic community that there's a paucity of lawyers that the community would consult. And so she's gone and done something highly innovative. I don't think it's disruptive, but it's highly innovative.
And George, you talked earlier about deregulation. So do you see now the landscape is such that it's really up to market forces to be the predominant driver of how the profession will
and that's
take shape
happening
in the future?
Even in the US, which is highly regulated, and people say not in their lifetimes will we see a change, a la ABS as we've seen in the UK. Even in the US, the market is finding ways to circumvent regulation. One of the most rapidly growing new law firms in the US is Elevate Services, which is in Australia as well. And when you listen to the leader there, Liam Brown, who is probably the most experienced of the LPO leaders in the world, he said, we don't see regulation as any problem. We're able to serve our corporate clients and our law firm clients directly, and regulators are not a problem. Now, there may be an element of bravado in that, but Axiom Law, it started in 2002 in New York, has found no problem at all. It's found lots of resistance from the organised profession, all of which so far has proved futile, and appears now to be dwindling. But Axiom Law is growing 30% compound, whilst most large law firms are growing 2 or 3%, if that. Now it's growing off now quite a large base. It originally was a small base. So we don't think regulation is the problem. We think an understanding, it's not going to stop the new law phenomenon, the innovation phenomenon, and certainly not going to stop big law innovating. Culture is going to stop big law innovating, is the real challenge, my point about inertia.